joining us today. I wanted to talk about the tax case involving Mr. Azruddin Mohamed and the GRA. The GRA has decided to appeal Justice Fasad's ruling yesterday, and that ruling, for context, states that the Revenue Authority could not impose post-clearance taxes. So I guess in the first instance, maybe can you tell us how does that ruling affect the state's ability to recover taxes due?
As I have said recently on more than one occasion, the state's power vested in various pieces of legislation to recover taxes that are due, owing, and outstanding is second only to the state's ability and power to defend itself. In other words, the state's power to recover taxes is a fundamental power, it is a sacrosanct power, and it's a power that is of paramount importance. If you look at debts, for example, the way debts are ranked, taxes is accorded the highest priority in the hierarchy of debts that a person owes. Taxes is the lifeblood of a nation. Taxes is what runs a country. And that is why the state is invested with this huge repertoire of power to assess taxes. And the state is given exceptional ability in law and by law to do things that may look extraordinary in order to recover taxes. That is the nature of taxation and the state's power to recover taxes. What this judgment in essence has done is to render ineffective, to cripple the state's power to recover taxes. The state, by law, in a series of legislation, has 7 years to recover outstanding taxes and can, in various pieces of legislation, go back over that 7-year period to reassess and to recompute taxes already assessed. And that is contained in the Income Tax Act, in the Customs Act, in the Property Tax Act, in the Companies Act, and in various other pieces of legislation. So, if this judgment is correct, what it means is that every time a taxpayer presents his payment of taxes and the GRA accepts that and processes it, that taxpayer can never be assessed, and GRA could never subsequently go back and say, you know what, you have provided me with fraudulent particulars. That power that GRA has by this judgment has been rendered nullified. Now, that strikes at the very heart of a state, because the state sustains itself from the collection of taxes. Mm-hmm. Imagine if whenever every company files their tax returns, it has to be accepted by GRA, and then and you pay, and then GRA retains a power to scrutinize it, and if it finds discrepancies, if it finds fraud, and I will deal with fraud later, then GRA is duty bound to reassess and recompute the taxes and embark on a process that allows the taxpayer due process in the challenge going forward in getting to what the right taxes are, right? So this judgment is wrong. It's almost, it borders on irrationality, and I say so with the greatest of respect. And as I said, it interferes with one of the most sacrosanct power of the state to collect taxes. Now, many times, and in almost every occasion that you present your tax returns or you make a declaration, there are forms that you have to sign. And those forms themselves are provided for in the law. And those forms that you sign say that you are binding yourself over to the GRA for a reassessment at a later stage in relation to whatever you have submitted. So that's a general principle. This judgment obviously is an aberration. It cannot withstand objective scrutiny, because here you have a judicial officer that is taking away from the state power that Parliament has vested in the state. And that is the ratio decidendi of the judgment. Taken to its logical conclusion, GRA has lost the ability to ever reassess and recompute taxes, and is bound by every declaration and every submission that a taxpayer pays. So taxes in the country now will be determined by the taxpayer and not the state. So newsroom submit 10 years of returns and they make a loss, and GRA is bound to accept it. Once they receive it and they issue some document to say that they have received it, they have lost all power to scrutinize, examine, interrogate, investigate whatever you have submitted, irrespective if they have evidence that you have submitted fraudulent information and fraudulent documents. At what level can that ever make sense? And that is the effect of this judgment.
Mr. Nandlall, you alluded to earlier that there is some element of fraud involved in this case that may not have been wholly considered. Can you speak about that?
My understanding is that the Guyana Revenue Authority presented evidence to the court to show that the declaration that was made, or the declarations that, well, the declaration that was made here, priced the vehicle, the cost price was some 76,000 US, that there were evidence produced that the cost price of the very vehicle when it was purchased was close to 700,000 US, that monies were transferred, the near 700,000 US was wire transfer to the United States, but only one of the transfers was used to purchase the car. That was 76,000 US, and that an agreement was manufactured to show that the car was purchased for 76,000 US. But the real agreement of where the car was purchased for nearly 700,000 US was produced. So clearly on the record before the court, you had fraud being established. And fraud in law unravels everything. Once a taxing authority has evidence of fraud, there is no discretion anymore, but a duty crystallizes on that taxing authority to go forward to get the right amount of taxes that should be paid. Recall, custom duties, for example, is ad valorem, meaning it is based upon value. The higher the value, the higher the taxes. Every Guyanese who listening to me, they pay their rightful duties on vehicles that they purchase at the wharf or from importers. You don't think every Guyanese would like to buy a Land Cruiser or a Lamborghini? But many of them can't because of the duties that are chargeable and leviable on these types of vehicles. But this gentleman believes that apparently he's special and therefore the tax laws of this country should not apply to him. And he has managed to secure a judgment from a court that stamps an imprimatur of legitimacy on what clearly is based upon the evidence. Evidence of fraud that must form the basis for a reassessment at a subsequent time.
Mr. Nandlall, of course, I do want to ask, how do these proceedings and the ruling...
No, before we get to that,
sure.
Let me explain the post-clearance audit a little. This is nothing new. As I said, the state always has a power under the various pieces of legislation regarding taxation to go back and reassess. Post-clearance audit is a mechanism that forms part of that large reservoir of powers. And it is born out of the Kyoto Convention. And it is a mechanism recommended by the World Custom Organization, of which Guyana is a part. In 2017, this special unit was established to deal specifically with post-audit clearance. What that means is that when if for example, every time a container comes on the wharf, an importer brings a container, the customs officers are to check every single item in that container and assess it and interrogate it as the law requires. The container will never leave the wharf. So what you do is that you do samples from that container and you assess the value. And the importer signs a form that is called a C-32 form, in which he binds himself to an undertaking that the GRA can come back and do post-clearance audit if they find evidence of a fraud. That would have occurred in this case. In other words, though you are making the declaration and the declaration is accepted and duties are levied based upon that declaration, you sign a form to say that the GRA can come back to do what they call post-clearance audit if they uncover evidence of fraud. Here, evidence of fraud was uncovered. And therefore the GRA has a power that you have agreed to. The declarant agreed to it in a C-32 form. I don't know whether the judge considered all these matters. No doubt these matters would have been put before the judge because the GRA, I see, was ably represented by a number of attorneys at law. But quite apart from that, the general legal power of the GRA to go back and reassess is an undoubted power that this judge here is saying that they can't exercise it. And there's some mention that there must be some criminal proceedings and there must be a conviction on those criminal proceedings. That is absolutely wrong. And I say so again with the greatest of respect. Taxation can be taxation, the taxation legislation provide for two paths to recover taxes. The criminal path and the civil path. And the laws are structured in such a way that they can be independently pursued. Obviously, you can't do them at the same time, right? So that's what I want to say on that issue.
Yeah, sure, AG. It's perfect that you mentioned that, because my next question is, I just wanted to know, how do these proceedings and yesterday's ruling affect the ongoing extradition proceedings?
It has no impact whatsoever on the extradition proceedings. What would have had impact on the extradition proceedings would have been the criminal proceedings in the magistrate's court, which were duly withdrawn after careful consideration of the legal implications by the lawyers involved. So there's absolutely no connection. I am happy that the GRA has signaled an intention to appeal this case. In fact, the GRA has no choice but to appeal this case. And an Attorney General cannot remain silent in view of a pronouncement from a court that says that the state can't exercise its legal repertoire of powers to recover taxes that are due and owing. I hope that the appeal will be filed quickly, and every effort will be made to ensure that the appeal is heard and determined quickly in the legal system.